Trademarks. Trademarks are symbols like logos that distinguish your goods in the marketplace. Some webmasters don't really use trademarks. If you have a website like poker listings, that's just a generic term. It's not really a trademark. Trademarks have to be distinctive. They have to be able of being recognized in the marketplace, not just being generic terms, and they have to be able to be recognized as representing your goods. As a webmaster, one of the things you want to be thinking about is, do you want a brand that people will recognize, that you'll build up and build brand equity in over time? Trademarks can be registered. When you register a trademark, you register it in a particular geographic area like the US or the European Union. And trademarks are registered in particular classes. There's 41 classes of goods. Examples of classes are class 9 is computers, data storage, 28 is games, 38 is telecommunications, 41 is education and entertainment. Those are common classes to use when registering trademarks. You can't register everything as trademarks. They can't be confusingly similar to existing trademarks. They can't, as I said, be just descriptive. They can't just describe characteristics like quality, the purpose, or the geographical area. And they can't be customary words that are used in the industry. Like you couldn't register the word casino as a trademark name. Some benefits are that trademarks let others know that the name is yours, that might be considering names they're using. They allow you to take legal action against someone who tries to use the name for themselves when they're not representing your goods under license from you. It's your property, so when you talk about what assets you have that you might sell if you terminate your business, then they become assets. And there's also some privileges that domain name holders have when they're with names that are related to their trademarks. One example is when there's sunrise periods on new domain names. Generally, there's a period of time where only trademark holders can register the domain name. And in certain types of disputes, you may be able to get control of a domain name or stop someone else from using it. So let's talk about a little bit what it takes to do trademark registration. Since it's by geographic area, I'm just going to give a few examples. In the US, there's a Patent and Trademark Office that has a website. You can search for other trademarks registered on all the Trademark Office websites, or at least all the major ones. And it costs about $300, $275 or $325, depending on how you do it and whether you can use one of the pre-canned descriptions for your trademark to register a trademark for 6 years in the US. And I gave some examples here of trademarks that are registered right now in the US. CasinoCity, which is one of my company's trademarks, is registered. CasinoMeister has a trademark registered in the US. Gamtrack has one. Similar in other countries, the UK, CasinoCity has a trademark registered in the UK too. And the EU is a commonplace. CasinoMeister is an example of someone who has an EU trademark in several classes. EU trademarks are a little bit more expensive, but they also cover all the countries in the European Union. Okay. So when you register a trademark, there are searches you can do. This is a search on the TEST system, which is the US Patent and Trademark Office search for trademarks. Now I mentioned that our company has a trademark on CasinoCity. I noticed earlier this year that there was another company trying to register a trademark for the term CasinoCity. And when I drilled down on it, I could see it was a company called DNA Games. And they actually have a Facebook game. This is a screenshot of it. It's a sim game where you can build a casino and play around with it. And it actually ends up, it's become a very popular game on Facebook. There are about 1.8 million monthly active users on it right now. It was just launched a few months ago. What happened is that the Trademark Office responded to their trademark request, and I was able to look that up and see that. I went and looked at the detail, and basically they sent a letter back to their application for the trademark, and I've sort of summarized it on the next page. Basically, the trademark officer and the patent and trademark officer rejected their trademark application on several grounds. The primary one was that it was too close a use to our use of it. It was for a game, and ours was for information in the gaming industry. And so they rejected that. And there were some other things, like they actually applied and given reasons in 3 different classes, but only paid the fee for 1 class for the registration. So it was rejected for that reason too. In this case, having a trademark for us was a really valuable thing to do, because the Trademark Office took that action. Now, that doesn't stop them from using it. That's a civil matter between us and them. I'd already sent them a cease and desist informally, and they understand that they have to deal with us. So we'll either license it or for some type of consideration, which will be valuable for us, or else we'll make them stop using that name, because it definitely is causing confusion in the marketplace. It ended up within a week of that game being launched, I had contacts from 4 or 5 people. Hey, I see what you've done. And it's kind of like, no, that wasn't us. It was someone else using our brand name. Having a trademark doesn't mean that no one else can use the trademark name at all. This is a kind of funny example. This is actually from the Chilling Effects website, which does publish a lot of examples of cease and desist orders. There's a website, ThinkGeek, that publishes an April Fool's Day joke each year. And this year, April 1st, 2010, they published an article for Canned Unicorn, the other white meat. And those, I don't know if everyone knows, but in the US, the National Pork Office uses the other white meat as a trademark term for pork, and they do have big advertising campaigns around that and everything. And so they weren't too happy about this spoof on the other white meat. So they actually sent them a cease and desist order, which is shown on the right-hand side of the page here, citing all their trademarks for use of the other white meat and demanding that they stop using that term. Now, this is actually an example of fair use of someone else's trademark. It was for a parody and a spoof on that. And that was actually the example that Chilling Effects gave as the sort of funniest cease and desist that they'd seen recently. There are a number of forms that trademark infringement takes on the web. I think most people have heard of them. Cyber squatting is one example, where you buy up a domain name based on someone else's trademark and then try and hold them hostage to some money for getting it back. Those generally will be resolved in favor of the trademark owner if they're really with that objective. Another example is using a competitor's meta tags on a website to try and get search engine traffic when someone's looking at a competitive product with that trademark on a different website. Using trademarks on a website to falsely claim some relationship with that party. Those are examples of infringements. There are very gray lines around some of these things. I mean, the examples I gave are examples that are clearly fraudulent, but there can be uses that are border line-ish around those things too. Okay. That's the end.